So a very pleasant good evening to one present here. I am Tarang, junior contributor at Just Corpus and the host for today's session. I, on the behalf of whole team of Just Corpus, welcomes you to this very session, which is pertains to same-sex marriage. And to be very precise, same-sex marriage is union or partnership. How to balance social good and individual freedom. Before we delve into today's discussion, I would like to brief you about Just Corpus and the eminent speaker of today's session. So, Just Corpus is an edtech platform established in 2020, comprising of legal professionals. This comes to consolidate various aspects in chain of law under single umbrella. With an impressive reach of 600K clicks per month on a website, Just Corpus was inspired by the growing needs of law students. As part of its initiative, Just Corpus has introduced an interdisciplinary journal known as Just Corpus Law Journal. Now, shifting our focal point to today's main agenda, our guest speaker, none other than Mithilesh Narayan sir, as will be delivering the session on same-sex marriages. Mithilesh sir is an assistant professor and deputy director of Center for Social Defense and Gender Studies Law at Sardar Patel University of Police, Security and Criminal Justice, Jodhpur. He has previously worked as assistant professor of law at Raksha Shakti University in Ahmadabad for the state of Gujarat. He has also been an invigilator in various university exams, and to very precise UGC-NET exams as well. He is also a senior editorial member at Just Corpus. Without further ado, I would like to hand over the floor to Sir for insightful knowledge in same-sex marriages. Over to you, sir.
Thank you. Thank you, Mr. Tarang Arora and Just Corpus and Mr. Ayush Pandey. And from my side, I welcoming all my viewers and the listeners who joined here through the different, you can say, social media. So basically, when Mr. Ayush Pandey contacted me to talk on any of my choices topic, I selected this topic because I have worked on it in my doctoral research and the postdoctoral research also. It was during 2006 to 9 and then 11 to 13, 2011 to 2013. So we are, you can say, going through a transformation in relation to the sexual orientation, not even in India, but many countries where the societies are traditionally bound, uh, running through the customary laws alongside with the constitutional law, etc., and other laws also. So before we start, I would like to tell you that I divided this whole talk on some of the major headings like what is the sexual orientation, how many kinds of sexual orientations are in existence, and then how what are the population in Indian scenario, because in terms of the religion, because we are having more and more, you can say, religious societies existing in our country. Then there will be the scenario we will discuss related to the laws existing in the world around on the same sex marriages or partnership or unions, different name given by the legislature of different countries. And then we will move to the US Supreme Court judgment, which is known as a Hodge judgment or Objerfeld versus Hodge of 2015, because that was the philosophical foundation to recognize the same-sex marriage in USA. And then further we will move to the to discussion of the case in Indian context like Supriyo and Navtej's Johar case. And we will also look into the debate, not whole debate, but very important or pertinent part to our debate. And then I will try to put my opinion on the topic that what is best suitable option for Indian context. In the Indian context, whether we allow same-sex marriages or we allow the union or partnership, or what can we do to protect both the things, the social goods, which is covering the all other aspects or all other sexual orientation, likewise heterosexual, which is majorly existing in India, and how we can protect non-heterosexual individuals or a union in without hampering the right of the heterosexuals. So let's start with our some of the basic aspects of sex or gender and sexual orientation. And as we know because every day or now we are hearing these you can say definitions. Likewise, sex is actually, we know it's a biological construct, and nobody can claim that I am the full or complete man or a complete woman, because it's, if you look to the, or if you go to the medical inquiry, there are majorly 8 factor inquiry to decide anybody's sex, whether it is male or female. So these 8 factors inquiry, it is not necessary that everybody is fitting in all 8 inquiries. सो एक तरह से कहें कि पूर्ण पुरुष या पूर्ण स्त्री जो है, किसी को भी लेबल करना, इट्स वेरी टफ टास्क, बिकॉज no one can be perfect in all 8 factors. So but we can understand that there are the two axes. One side there is a male and other side the female. So in between these two axes, all other sex and gender variations existing. Somehow they are more towards the male side, some people more towards the female side. And that's why we are saying that every man having the some of the aspects of woman, every woman having some of the aspects of the man, or male or female, you can say. So sex is a biological construct and gender is a social construct, which we would like to see. Like if person is claiming that he is a male, we expect that he should behave like a male or masculine. And if female is there, then we expect that she should behave like a feminine gender or woman attributes who should she should bear. So these are some basic concept, and then we move to the sexual orientation, which is actually the attraction of an individual towards the other person. Now, if attraction is towards the opposite, only opposite, then it's known as a heterosexual. If it attracts toward the same sex, then it's known as a homosexual. And if person attracts towards both the sexes, it knows as a bisexual. And there are the people who are completely not interested in the sexuality, which is asexual. And nowadays, there are some of the cases where people claim that they are omnisexual, means they are attracted toward all sexes and all genders. So one more, you can say, a fourth generation kind of people are coming into the society, which known as a pansexuals. So even in the superior cases also, the Advocate General Mr. Mehta told that there are the 72 or more than 72 kind of variations existing related to sex and gender. So it's quite tough to because it's a subject of the medical science, or we can say it's in terms of the gender, we can say it's something a social construction, so we can study in a social aspect also. But if we talk about the sex only, then it is a completely medical terminology, and including the various kind of the sex and gender variation. There are the intersexual people, there are the transsexual people, there are the transgender people. So it's, you can say it's an umbrella term covering many aspects of sex and gender. Now, moving to the our my second head, that is how much religious population existing in India. So tentatively, if we look to the government data, presently there are 138.8 crores people. That is tentative projected population, we can say. That is the data of July 2020. So in that data, if you look to the division as per the religion, then 79.8% of the people are Hindu, 14.2% are Muslim, 2.3% are Christian, and 1.6% Sikhs. So why I am discussing this religious aspects, because major the opposition for the same-sex marriage coming from the religious side. So we should look, and their claim also about the equality, marriage equality. So in Indian context, marriage is basically governed by the religion and traditional, you can say, or customs. So every religion having their own parameters or own eligibility criteria to move into this institution. In Hindu, that is a sacred, you can say, custom, and you will get the moksha only, you will if you will be married, you will get earth and calm the sadhana only by moving to the marriage. And even a male get the eligibility to do the yagna only when he got married. You have also seen the, if you go to the mythology, you can see the example of Lord Rama when he going to establish the Jyotirling Rameswaram. There were the, you can say, compulsion for the wife while doing this puja. So everywhere there is a condition of a wife for performing any kind of puja. So, and more so, we need exactly the, you can say, objective of, one of the objective of the marriage, apart from this mythological objective, that is the procreation. So the procreation by the natural means only can happen through the male and female. So this is about the Hindu law. Similarly, if you move to the Islam, then in Islam, marriage regarded both contractual and sacred. So nikah in Muslim law has three components. First, a willing couple. Second, witness, and third is the meher. So the concept of meher and iddat revolve under Muslim law, and for that, for the validity of this, the two-person of the opposite sex required. So where meher is seen as a gift from the groom to the bride as a token of respect. So if we are talking meher and iddat, both concept related to the male and female. So opposite sex is required. So if you look any religion, in Christianity also, the argument uh, based on the biblical passages, which says that three fundamental element of the Creator's plan for marriage. The marriage is not the creature of any state, rather God created male and female in his image. God blessed them, saying, "Be fertile and multiply, fill the earth and subdue it." So they also believe through the biblical passage that there are the requirement of male and female. So majorly, what is the importance of marriage? The first is the procreation, then creation of family, cohabitation, shared value as the important markers. And at the same time, these traditions also recognize in a varying degree importance, companionship, spiritual union, friendship, togetherness of the spouses, and the eligibility also decided by the customs and religion. Now, if you look to the our past and existing law, you will also see there are the ceremonial provisions given in the marriage laws, like Section 2 of the Anand Marriage Act 1909. In that also, Section 3B of the Parsis Marriage Act and Divorce Act 1936, Section 10, 11, and 25 of the Indian Christian Marriage Act 1872, Section 7 of the Hindu Marriage Act 1955, all these are explicitly recognized the religious ceremonies to solemnize the marriages. Even in the Muslim Personal Law Shariat Application Act 1937 clearly says the application of personal law to marriage, including the nature of the ceremony. So, but we see that to pick the choices partner, it's not absolute, and it's subject to the two-dimensional regulation. First, minimum age of the partner, and the exclusion as to the prohibited degrees. So these two conditions existing everywhere. Now, if you look to our legislation also, that age required for the male, that is 21, and for female it is 18. Now, if we look to the worldwide situation of the marriage equality, we will find that 35 out of 194 countries have recognized the marriage between non-heterosexual individuals. And these recognitions, among them, 23 countries have legalized same-sex marriage nationally through legislation, like Australia, Ireland, Switzerland, all these legalized same-sex marriage through the legislation. Then 10 countries have legalized same-sex marriage nationally through court decision, like Austria, Brazil, Colombia, Costa Rica, Ecuador, Mexico, Slovenia, South Africa, Taiwan, and United States. Among this, South Africa legalized this after the court mandate, and Taiwan also enacted legislation of legalization of same-sex marriage through the court mandate. So this is the present situation where the same-sex marriage allowed, and you can say their name may be different, but they allowed non-heterosexual marriages. Now, if we go through the philosophical foundation, and if we discuss the Observable Hodges case, that is of 2015, the Supreme Court of US ruled by 5-4 that fundamental right to marriage is guaranteed to same-sex couple by both the due process clause and the equal protection clause of the 14th Amendment of the Constitution. And while deciding this case, court listed four distinct reasons to decide this. The first reason was the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Second, the right to marry is a fundamental because it supports a two-person union unlike any other in its importance to the committed individual, a principle applying equally to same-sex couples also. Then third, the fundamental right to marry safeguards children and families and thus draws meaning from related right to child rearing, procreation, and education. As same-sex couples have children and families, they are deserving of this safeguard. Though the right to marry in the United States has never been conditioned on the procreation. Fourth, but in India it is conditioned under the procreation also. So we should not forget this. The fourth and lastly, marriage is a keystone of US social order. And there is no difference between same and opposite sex couple with respect to this principle. So consequently, preventing same-sex couples from marrying puts them at odds with the society, denies them countless benefit of marriage, and introduces instability into their relationship for no justifiable reasons. But in this judgment, Chief Justice John Roberts wrote a dissenting opinion with the Justice Scalia and Thomas. Roberts stated that no prior decision had changed the core component of marriage, that it be between one man and one woman. Consequently, same sex marriage bans did not violate the due process clause. He stated that marriage which he proposed had always had a universal definition as the union of a man and a woman, aroused to ensure successful child rearing. Roberts further argued that the fundamental right to marry does not include a right to make a state change its definition of the marriage. He also suggested the majority opinion could be used to expand marriage to include legalized polygamy. So, because this judgment came by 5-4, so he said that it may go further to the polygamy also. Roberts asserted that even without having any marriage rights, same sex couples remain free to live together, to engage in intimate conduct, and to raise their families as they see fit. Similarly, in dissent opinion, Justice Thomas claimed the same and asserted that states have imposed no restriction that would limit same-sex couple. Now, if we compare it into the Indian context, the US society is different on the very basics of the phenomenon, that is our society based is on the religion and customary law. And we are having you can say enormous amount of customary law traditions. It may be not you can say in line of the constitution or contrary to the constitution or corresponding to the constitution. That doesn't matter, but we are having a society which runs through the customs also, traditions also. So putting this judgment as it is to India, or looking for the justifying our claim, it's having some limitations related to Indian society. So, as we know, in Navtej Johar case, the same-sex partners, you can say, successful to decriminalize the Section 377 between the consented adults, and uh, court also recognized their right, and they also told that they should not be discriminated on ground of this. But then in Supreme case, they were further moved to the Supreme Court for the marriage equality. So the actual claim was in Supriyo case that right to marry on equal terms with the rest of society. It is right not to discriminated against in access to marriage, and a right that is of particular importance because, as has been noted, there is a range of other fundamental rights that are inextricably bound up with the ability to access the institution of marriage. Petitioner also argued to consider their claim under the Special Marriage Act, and it should be interpreted in a gender neutral manner, with terms like husband and wife read as a spouse, as the language allows for a gender neutral interpretation. Now, they further ask that by denying the recognition of non heterosexual marriages, deprives the individual of expressive and material benefit like matrimonial and child care related benefit, property benefits, monetary benefit, evidentiary privileges, civic benefit, and other miscellaneous benefit like self-definition, autonomy, or pursuit of happiness. So these are the petitioner's claim. But after considering the argument from both the side, the judgment came on 17th October 2023, and the bench pronounced four judgments. It was actually five judges bench, but total four judgments came and written by the Chief Justice D.Y. Chandrachud, Justice S.K. Kaul, Justice Ravindra Bhatt, along with Justice Hima, and then Justice P.S. Narasimha, respectively. So four different judgments came, and they unanimously held that there was no fundamental right to marry in India. Further, it was also unanimously held that the Supreme Court could not legislate upon queer marriages, as the same would violate the doctrine of separation of power and would amount to entering the domain of the legislature. However, all the judges on the bench had agreed that the Union of India, as per its earlier statement, shall constitute a committee to examine the right and entitlement of person in a queer union without legal recognition of their relationship as a marriage. The court had also unanimously held that the queer couples have a right to cohabit without any threat of violence, coercion, of interference, but refrain from passing any direction to formally recognize such relationship as a marriages. Judges have rejected the plea on the ground that civil union cannot be graduated into marriage since marriage is not a fundamental right, not a claim or entitlement, and it's only the statutory rights. Judges unanimously had held that transgender person in heterosexual relationship had the right to marry under existing law, including the personal law which regulate their marriages. Similar kind of provisions they made for the intersex people also. Now, if you go through the individual, you can say approaches, the few things which I would like to talk on this or I would like to ponder that first, CJI Chandrachud said, queerness is a natural phenomenon known to India since ancient time. It's not urban and elite. Because that was the claim of the respondent that it is not a, you can say, existing universally and it's only urban or elite concept. But it's actually existing in villages also. I have also seen, I am agree to the this part of the judgment. Then there is no universal conception of the institution of marriage, nor is it is static. Under Article 245, 246 of the Constitution, read with the entry 5 of List 3 of to the 7th schedule, it lies within the domain of Parliament and the state legislature to enact laws recognizing and regulating queer marriages. Marriage has attained significance as a legal institution largely because of regulation by the state. By recognizing relationship in the form of marriage, the state grants material benefit exclusive to the marriages. Constitution does not explicitly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental rights based on the content accorded it by the law. In Article 15.1, the word sex must be read to include sexual orientation. That was because of the giving the benefit of the for against the any discrimination. So they are betting for anti-discrimination laws for non-heterosexual people also. And then intersex person who identify as either male or female have the right to marry under existing law, including personal law, which regulate marriage. And then they directed to the government for uh, make provisions under which they shall not be discriminated. Similarly, the some interesting aspect from the Justice Sanjay Kishan Kaul's judgment. He said that non-heterosexual union and heterosexual unions marriages ought to be considered as a two sides of the same coin, both in terms of recognition and consequential benefit. The only deficiency at present is the absence of suitable regulatory framework from such union, and that framework lies in the court of legislatures. The need for an anti-discrimination law, Justice Call, in agreement with the opinion of Honorable Chief Justice that there is a need for a separate anti-discrimination law which inter alia prohibit discrimination on the basis of the sexual orientation. Legal recognition of non-heterosexual union represent a step forward towards marriage equality. At the same time, marriage is not an and in itself. So, in an argument also, or during the proceeding also, Justice Call said that the uh, incremental, you can say, progress is always good rather than immediate, you can say, changes. So, he bet for the incremental changes. Then he said that the capacity of non-heterosexual couple for love, commitment, and responsibility is no less worthy of regard than heterosexual couple. Let us preserve this autonomy so long as it does not infringe on the rights of the other. Now, in one more judge, Justice Narasimha also wrote his opinion in a different, you can say, judgment. He said that marriage as social institution and the status of right to marry is completely based on the social institution. There cannot be any quarrel in that marriage is a social institution and that in our country it is conditioned by the culture, religion, custom, and usages. It is a sacrament in some communities, a contract in some other. State regulation in the form of codification has often reflected the customary and religious mooring of the institution of marriage. And after going through the Chief Justice opinion, he divided that there are the two types of status existing in terms of the relationship. First, the relationship which do not have a legal consequences, like brother and sister. They are not having any legal consequences. One cannot move that after tying the rakhi, bhai ne mujhe rupaye nahi diye. So such kind of things, you can say they having no legal consequences. On the other side, union which have a legal consequences, like a marriage, or in present context we can say live-in relationship. These are having some legal consequences. So Justice Narasimha positively mandate the state to grant recognition or legal status to union from which benefits will flow, that the doctrine of separation of power is violated. So in its you can say simple terms we can say this, as per the Justice Narasimha also, to recognize such union, the power flowing from the legislature, because they are not competent to deliver any such kind of guideline or you can say mandatory provision. He further opined that it would not be constitutionally permissible to identify a right to a union or an abiding cohabitational relationship mirroring the institution of marriage. Similarly, on the other hand, Justice Ravindra Bhatt and Justice Hima Kohli, they also together given their judgment, and they stated that if provisions of Special Marriage Act are to be constructed as a gender neutral, as the petitioner proposes, it would be possible for a cis woman's husband to file a case or create a narrative to manipulate the situation. It means that husband can, if we will make gender neutral, then it's easy for the husband to take advantage out of it and further do injustice with the woman. And it is good on the paper, but actually it is an effective tool to remedy a perceived injustice. After due elevation about its necessity. A law which was consciously created and fought for by women cannot therefore an interpretative slight be diluted. So basically, it's a very meaningful law to protect the woman. And if we will dilute it by doing gender neutral, then it may be misused by husbands also. So, to summarize, they have concluded and given some direction and said that there is no unqualified right to marriage except that recognized by statutes, including space left by the customs. An entitlement to legal recognition of the right to union, akin to the marriage or civil union, or conferring legal status upon the parties to the relationship, can be only through enacted law. A squitter of this is that the court cannot enjoin or direct the creation of such regulatory framework, resulting in a legal status. The finding in 1 and 2 should not be read as to preclude queer person from celebrating their commitment to each other or relationship in whichever way they wish within the social realm. And previous judgment of this court have established that queer and LGBTQ plus couple to have the right to union or relationship under Article 21, be it mental, emotional, or sexual, flowing from the right to privacy, right to choice, and autonomy. So they does not extend it to right to claim entitlement to any legal status for the said union or relationship. So after going through it, what we can come up, you can say, from this judgment. So the first thing that if you look to the separation of power, the power lies with the legislature to create the new law. Like they can create the new regime of taxes. Only legislature can create the social welfare benefits. Court cannot do. Court not having any mechanism to study the society, that what society, what kind of welfare benefits they want. And because these are not areas which stop merely at a declaration of right, but following a declaration of right, the remedies which are sought clearly with the province of the legislature. Because right without remedy is nothing. If you are giving rights, then why you are giving right? Because there are chances of the violation. Only then that's why you are declaring the rights. And to protect that right, one should have a mechanism. Otherwise, it will go in a vain. So, no doubt, those who seeks marriage, they seeks it for the community and social validation of relationship. Sense of security it provides to the couple, greater financial support and security. Marital status by itself is a source of dignity, fulfillment, and self respect. It is an integral aspect for the ability to have and enjoy a family life. So, dignity was to treat everyone with the equal concern and respect. And same thing also argued by Dr. Abhishek Manu Singhvi, Advocate Abhishek Manu Singhvi ji, during the proceeding. On the other hand, there is one more aspect which covered by Attorney General R. Venkatramani, who representing Union of India. He stated that it is equally important to mention that granting legal recognition to a non-heterosexual union would lead to the dilution of heterosexual marriages. By citing the example of Netherlands, where he says more heterosexual couple opted for domestic partnerships after recognition non-heterosexual unions, and further stated that is why legal recognition is not given to them for to protect the institution of marriage. And I also agree, because as much as relaxation, or you can say enjoyment of right you will give, society will ask more for more and more. And nowadays it's common practice, or common, you can say, uh, in the modern, you can, generation, they think that marriage is a burden. They considered it as burden, because see, if we compare today's society to the earlier society, society based on the duties. In mythology also, there are the Putra Dharam, Pitra Dharam, Matu Dharam, and it means these all dharma means the duties, duty of a son, duty of a father, duty of a mother. So everybody was performing their duty. And by performing their duty, this at the same time they are protecting the rights of the other person. But now they shifted to rights. They are claiming rights, individual freedom, individual rights. And as much as you are giving liberty, they are asking for more and more. So to get rid from the marriage, the new concept came live-in relationship. Now, when court decided that live-in relationship is equal to the marriage, then they, I think they will come with a new one more new term to get rid from both of the things. So that is important, that if you allow such kind of thing, it's possible that heterosexual people also claim same thing to the non-heterosexual people. But let's debate on this also aspect in a later part. So undoubtedly, heterosexual marriages is still a marriage, but marriage which gain acceptability for the centuries. And Justice Narasimha also observed that, and he also said that alternative to marriage, when we say recognition, it may not always be recognition as marriage. Recognition can mean association which should entitle them to certain benefit. Recognition must be something which give them benefit. Without giving benefit, only recognize the marriage, it will not serve the purpose. So ultimate purpose is that they should live in the we live in society with the dignity, integrity, and the freedom corresponding to the heterosexual couples. And incremental changes always beneficial to the society. No society can survive on absolute freedom or absolute liberty. And marriage is a conventional and universally accepted social legal relationship across all religion and indeed considered as a sacrament. So after this judgment, a new development, or you can say new concept, came from the Madras High Court. In the case of Susma versus State, that was the writ petition number 7284 of 2021. So Madras High Court suggested the state to consider or coming up with the procedure of registering the deed of family association, recognizing the civil union entered into between the LGBTQAI plus parents in order to protect the fundamental right of person forming parts of the community. So as I told you, na, every time if you will give the liberty, or then you decide that liberty, no, you cannot enjoy this, or you will enjoy this liberty in terms of this name or this condition, the society will come up with a new term. So that this new term came deed of familial association, and where two-person will have a right to live in a relationship and will also get a right to protection. Now, in my opinion, see, if you can remove the transgender from this, you can remove the asexual from it because they don't want to marry, then you can remove intersexual people. So the only the people left is lesbian, gays, or bisexual. Now, if you allow marriage equality, what will happen? Whether we allow bisexual people to do two marriages at the same time with the female also and with the male also. So again, it will create problem for the society. So what is the best thing? So in my humble opinion, the best solution is that to regulate the union, it should be left to the state, and marriage should be left to the religion. So whenever we are anything we are ceremonize, or if you are Hindu, to go with the Hindu Marriage Act. If you are Muslim, then go with the Nikah. And if after due consultation, if state feel that yes, we can recognize the union, we can recognize the partnership, then they come up with the new law or anti-discrimination law and give them such rights where they can live in society with the dignity and integrity. So only this way we can protect our social fabrication, which is existing since last so many, you can say, years and years and decades. And um, according to my research, according to my, you can say, observations, I time which I spend with these guys, most of them are very emotional people. very sensitive. So if we will allow their partnership or union, at the same time we can observe them that how long their relationship will stay, whether they are changing their partner frequently, or if you will frequently allow them to change, then this, hundreds cases will come to the court, because then you need to uh, provision for divorce also, you need to provision for maintenance also, you need to give them a, you can say, rights of parents also. So I am not in against to give them all these things, but let them to prove in society that yes, their claim is right. They are, you can say, abiding citizens with the law, and only then we can, you can say, give them a equality. So I agree that changes must become in an incremental manner rather than a sudden changes. Sudden changes will not last for the long. Meanwhile, we can protect their right, their dignity. Anti-discriminatory law should be there, and all other property benefits and all other rights they should get. And state should recognize those rights. But for my opinion, giving marriage equality will not be a good idea. Yes, we can recognize their civil or civil partnership through the legislature, through the consultation with all the stakeholders of these those who are claiming the right. But giving marriage equality will not be a good idea. So this is my stake, or you can say my talk on this. If any questions or any, you can say, discussions required, it's over to you, Mr. Tarang and Mr. Ayush.
Thank you so much, Sai, for indeed a very informative session. You start from the very basic to the very complex. Now the floor is open for the question. But nevertheless, we have got few questions which you permit I would like to ask.
Yes, yes, sure.
So, sir, the very first question is some laws are specially mentioned towards a particular gender. For example, Domestic Violence Act. The word Domestic Violence Act is based on marriage and not on live-in relationship. So, sir, what can be done to overcome this?
It is already decided by several cases. I'm not recalling the name, but they told that in that judgment, they said that they are covered under the domestic violence. Live-in relationship given the equal status to the marriage. They cannot get rid by doing this such kind of act.
Okay, sir. Sir, the next question is in what ways does the intersection of gender, caste, and religion affects the experience of LGBTQI individuals seeking acceptance and recognition in India?
See, yes, I agree that there are the, you can say, maximum people having the homophobia or transphobia. Transphobia is actually the phobia related to the transgender. Like whenever we see Hijras on the road, or such kind of people who are actually the male and wearing the female attire, we try to get rid from it. We try to hide from those people. So acceptance to the homosexuals and transsexuals or transgender only come when we recognize it, means major society will recognize them, and it will come by the visibility. More and more they will be visible, more and more they will prove themselves that they are the normal people, and then only the society will accept. If they will do anything which is not as per the society, society will reject them. Like why Israel people, major society rejecting them? Because they are behaving abnormally in the public, and this abnormality always create prejudices against anyone. So their visibility, their behavior, and their status, they must they must take good education. They should come in the job, they do the job first. मीन्स ट्रांसजेंडर और होमोसेक्सुअल को खुद को एक्सेप्ट करना होगा, और खुद को सही से समाज में प्रस्तुत करना होगा. ओनली देन society will accept. If they themselves feel inferior, nobody will help them, because The major society, or you can say the heterosexual society, also failing to get the help of the psychologist, then how they people will get?
Yes, sir.
So
Yes, sir. So the next question is, how far the country like India, according to its social setup or historical aspect, is ready to the concept of same-sex marriages?
see, yes, we are not ready to accept, because no doubt the acceptance in a elite class is there. The concept is not elite and that is not urban. But yes, acceptance is elite and urban. That we can say. In a lower society, or you can say middle class society, it's not accepted. Uh, you can, means I have seen so many examples where police couldn't find the reason to suicide. So they should investigate the sexual orientation or gender identity of that particular person. ऐसा बहुत बार मैंने देखा है कि पुलिस को सुसाइड का कोई कारण नहीं मिलता, और उसके पीछे पुलिस ये भी नहीं देखती है कि इसके मरने का कारण क्या ये हो सकता है, जबकि पीछे वही कारण होता है कि वो he was having the same sex orientation, and he or she afraid to tell family, and instead of telling them, they think that it's better to kill themselves. So
Yes, sir.
there are the reason, and I I think that visibility of them is very important, and society acceptance only come when they will be visible, and along with this anti-discrimination law will play the crucial role. We have studied in law that law is an instrument of social change. So first, if we will introduce anti-discrimination law, then acceptance will come, and then gradually the partnership or union will be accepted, and then further after 20, 30 years, or if God allows, then maybe early to that we may recognize marriage also. But present status, it's quite tough to accept anyone for such phenomenon.
Yes, sir. Yes, sir. So we have two more pertinent questions. The very first being, what are the arguments given those countries where same-sex marriages is enjoyed by people after court verdict?
They are bound to follow the court verdict, and they are having the open society, not, I mean, we can say closed society like we are having our own customary law. Like I am telling you two or three example to satisfy the person who questioned it. In a one interview of that Puri Sankaracharya ji, Nishchalanand ji, one person asked about the uh, marriages in a prohibited degree existing in India, whether it is good in terms of Vedas or in compared to Vedas or Upanishad. He said that these are the lokachars. It's no doubt it is against the Vedas. Like in South, अगर मामा की लड़की से शादी हो तो they think that it's the best. Some of the communities in South, so they allows them to marry and they celebrate it. Similarly, he has given the example of Jagannath Puri, that if you want to Panda of a Puri, you need to be married in a 2.5 kilometer periphery of the mandir temple. Only you can be allowed. If you go outside, you will not be allowed. So these are the lokachar, means customs. So to get the acceptability related to that or eligibility related to that, they have to follow their custom. So such kind of things not existing in the Western society. Our society having different culture, different tradition. There means the customary law also changes. It might be the like Ayush Pandey and belongs to the community, and they are having different tradition. 400 kilometer in marriage, they same Pandey having the different tradition. So these customs prevailing very much, and Indian tradition, the customary law is very significant role. So in those countries, it's easy to recognize. if that is accepted by the society, the one thing, and they accepting, nobody bothers. In our society, many people bothers. So that's why they are having such kind of laws and equality and see, South African constitution um, added sexual orientation in, I think, in 1990s, 91, 92. They put the word sexual orientation in their non-discriminatory, you can say, parameters like sex, gender, sexual orientation. On all these terms, discrimination not allowed. So they are far ahead in terms of this, and our constitution or our this judgment allows now, or you can say in 2009, where this Naj Foundation judgment came. So society plays significant role.
Okay, sir. Okay, sir. So the very last question is, what should be done for the person who lives in same-sex marriages, as to the same right need to be entitled as far as the social, economic rights and benefits are concerned.
See that this judgment also saying that the rights should be protected, and they are having all the rights which is flowing from the Constitution of India: right to life, right to privacy, and right to celebrate their relationship. That is, they agree on all the aspect. They are only not agree on declaring the right to marry, because right, there is no such kind of concept existing in India related to right to marry or freedom to marry. They are having to frame the union, means form the union, live according to their will. Consenting adult can live. So all such rights existing. Yes, there are the remedies are not available to enjoy. So that's why court has given the direction to the state, and the state himself itself said in the court that they are forming a committee to decide the claim of those same-sex couples or same-sex people regarding the bouquet of the rights, which including social, economic, and other kind of rights.
Yes, sir.
So
Got it.
anti-discrimination law is very much, you can say, required to protect this community.
Thank you so much, sir. In closing, I, on the behalf of whole team of Just Corpus, would like to thankful and very thankful, grateful for the session and for accepting our invite to deliver such an informative session. We trust that the whole team in the session and the audience find it very knowledgeable and interesting at the same time. Thank you once again, sir. We eagerly anticipate to host you again. Thank you, sir.
Thank you, Just Corpus, for giving me this opportunity, and the all viewers and listeners. Thank you, and all the questions were also very pertinent, and I hope I given, you can say, justice with the topic agreed by the Ayush Pandey to deliver on this. And if any further question, the people, the listener can contact me. And thank you so much for giving me this opportunity.
Thank you so much for providing the golden chance to host you on our platform, sir. Our audience was too happy because we have shared a poll on the YouTube live chat, and 95% people have reacted it as a very good session, and 5% of the candidate has reacted it as a good session. So overall, it's a two positive feedback, 100% positive feedback. Also, the people keep on texting on the YouTube live chat that the session was too knowledgeable and it was too helpful in nature. So thank you so much, sir, for delivering such a wonderful lecture and for your precious time. We are glad to have you.
Thank you.